Welcome to Chapter 1, Data Protection for Children and Vulnerable Individuals. In this chapter, we'll explore the DPDP Act's special provisions designed to safeguard the personal data of children and vulnerable individuals, such as those with disabilities. Data protection laws must address the unique vulnerabilities of certain groups, particularly children and individuals with disabilities. Recognizing this, the Digital Personal Data Protection Act, 2023, introduces key provisions to safeguard their personal data. For children, these protections are critical to prevent exploitation through unauthorized data collection, misuse for marketing, or invasive surveillance. Similarly, individuals with disabilities face distinct challenges in managing and securing their personal data. The DPDP Act ensures enhanced safeguards promoting responsible and ethical handling of data for these vulnerable groups. Consent requirements for children. As per the DPDP Act, children are recognized as vulnerable data principals due to their limited ability to understand the implications of data processing. To address this, the Act introduces stringent requirements for obtaining consent when processing personal data of minors, defined as individuals under the age of 18. Key provisions. Parental or guardian consent. Section 9 of 1, the DPDP Act mandates that explicit parental or guardian consent is required before collecting personal data of children. This ensures that children's data is processed under proper oversight from a responsible adult. Example: imagine a mobile app providing educational services for children. The app must ensure that parents or guardians provide verifiable consent before the child can sign up and use the app. Verifiability of consent. Section 9 of 1. The consent obtained from the parent or guardian must be verifiable. This means the data fiduciary must confirm that the individual providing consent is indeed the child's parent or legal guardian. Example: consider a streaming service collecting data on children's viewing habits. To verify parental consent, the platform might require parents to upload identification documents such as Aadhaar to validate their relationship with the child. Data minimization for children. Section 9 of 2, the DPDP Act limits the types of data that can be collected from children. Only the data necessary for the stated purpose can be collected, and the collection of data not directly related to the service is prohibited. Example: in a children's gaming app, only data relevant to the gameplay, such as the child's username, may be collected. Collecting unnecessary sensitive data like biometric data or location data would be prohibited. 4. Special protections for children's data. Section 9. Children's data must be protected with enhanced measures to prevent misuse, such as exploitation for targeted advertising or profiling. Example: an educational app collecting children's data should implement strict controls to ensure that this data is not used for purposes like targeted marketing. Special provisions for children and persons with disabilities. Overview. The DPDP Act not only protects children, but also addresses the needs of vulnerable individuals, such as persons with disabilities. These provisions ensure that individuals in these groups can exercise their data rights without facing barriers. Data protection for persons with disabilities. Section 9 of 1. Individuals with disabilities often face challenges in providing informed consent. The DPDP Act requires reasonable accommodations, such as offering accessible forms and communication channels, to ensure they can understand how their data will be processed and can consent accordingly. Example: a website collecting data from individuals with visual impairments must ensure that the consent form is accessible. This could include providing audio versions of the form or using screen reader technology. Special categories of data. Section 8 of the DPDP Act recognizes that certain types of data, such as health or mental health data, are more sensitive. Special safeguards are needed for the processing of such data, especially when it involves children or vulnerable individuals. Example: a platform processing health data of children with disabilities must ensure that this data is handled only for legitimate health purposes and cannot be used for commercial profiling. Accessibility of consent mechanisms. Section 9 of 1. The DPDP Act mandates that data fiduciaries must offer accessible consent mechanisms for individuals with disabilities. This can include using simple language, offering alternative formats like audio, or providing assistance where necessary. Example: An online platform that processes personal data from individuals with hearing impairments must ensure that consent forms are available in sign language videos or provide closed captioning in videos. Prohibition of discriminatory practices, Section 9. The Act explicitly prohibits using personal data to discriminate against individuals with disabilities. Profiling based on disability or health data is restricted unless explicitly authorized by law. Example: an insurance company should not use health data of individuals with disabilities to deny them coverage or charge them higher premiums without valid justification. Enhanced protection against profiling. The DPDP Act offers enhanced protection against profiling for children and persons with disabilities. These groups cannot be subjected to automated decisions with significant consequences based solely on their data. Example: a healthcare app cannot use data on a child's health to automatically recommend treatments without human review, especially if the app relies on sensitive medical data. Targeted advertising restrictions. The DPDP Act places a restriction on targeted advertising for children under the age of 18, ensuring they are not exploited by advertisements based on their personal data. Example: a social media platform that caters to both adults and children must ensure that users under the age of 18 are not targeted with personalized ads based on their preferences, location, or browsing history. Role of data fiduciaries in protecting children's and vulnerable individuals' data. Data fiduciaries play a critical role in ensuring the personal data of children and vulnerable individuals is processed in compliance with the DPDP Act. These organizations are responsible for implementing the Act's provisions to safeguard these individuals' rights. Key provisions: transparency and accountability. Section 8. Data fiduciaries must be transparent about how they process the personal data of children and vulnerable individuals. This includes informing both the data principal and their parent guardian, in the case of children, about the data processing activities. Example: an e-commerce platform that collects personal information from children must clearly explain how the data will be used. For example, for account creation, order processing, or customer service, and obtain explicit parental consent. Data protection by design. Section 8. Data fiduciaries must incorporate privacy and security measures from the beginning of any data processing activities. Only the minimum necessary data should be collected, and it should be securely stored. Example: a mobile app for children's education must implement encryption and other data protection mechanisms to safeguard students' information from unauthorized access. Regular audits and compliance. Section 10. Data fiduciaries must conduct regular audits to ensure they are compliant with the DPDP Act, especially regarding the processing of children's and vulnerable individuals' data. These audits assess data collection methods, security measures, and consent management processes. Example: a tech company offering a children's app should conduct data protection audits regularly to ensure that it complies with the DPDP Act and upholds children's privacy. Case Study 1. Data protection for children in online platforms. Background: an educational platform offering online tutoring services to children started collecting personal information, including sensitive data like academic records and health information. Problem: the platform failed to obtain parental consent before collecting personal data from children. Additionally, the data collection was not limited to necessary educational purposes. Solution: the platform revised its data collection practices by obtaining verifiable parental consent, restricting data collection to educational-related information, and implementing stronger security measures to protect the data. Outcome: the platform ensured compliance with the DPDP Act, and parents were provided with the option to review and delete their child's data whenever necessary. Key takeaways: parental consent is crucial. For children under 18, parental or guardian consent is a fundamental requirement for processing personal data. The consent must be verifiable, and the data processing must be conducted with utmost care to protect children's privacy. Stronger safeguards for vulnerable individuals. The DPDP Act provides additional protections for vulnerable individuals, including children and persons with disabilities. These safeguards are designed to prevent exploitation and misuse of their personal data. Data minimization and purpose limitation. Data fiduciaries must ensure that only the minimal amount of data necessary for the specified purpose is collected, particularly when dealing with sensitive data related to children and vulnerable individuals. Compliance with special provisions. Organizations collecting data from children or vulnerable individuals must comply with the special provisions under the DPDP Act to avoid penalties and legal actions. Accessibility for vulnerable groups. The DPDP Act mandates that organizations provide accessible consent mechanisms for vulnerable individuals, including those with disabilities. Conclusion. This chapter highlighted the unique provisions under the DPDP Act for protecting the personal data of children and vulnerable individuals. These provisions ensure that personal data is processed responsibly and ethically. Data fiduciaries must follow these guidelines to maintain compliance with the law and protect the privacy rights of these groups. In the next chapter, we will explore sensitive personal data and the specific provisions for processing such data under the DPDP Act. Thank you for engaging with this chapter. In the next lesson, we will dive deeper into sensitive personal data and its handling under the DPDP Act. Stay tuned. Thank you for joining this session. In the next lesson, we will explore the sensitive data and special categories of data, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.